SJC-12889, Commonwealth versus Felix Melendez.
Attorney Votero.
Good morning. May it please the court. My name is Brett Votero, and I represent Felix Melendez. I want to begin by confessing that since I first read the affidavit that I've challenged in my brief, I've been nervous. It's been several years, and I've been nervous. I've been nervous because I was trying to understand, had I missed something? How had this warrant issued by a judge escaped review? How had this warrant gone through 3 trials with an experienced defense counsel escaped review? I was nervous until I got the Commonwealth's brief and until last Friday when this court issued its decision in Perry. I thought I had missed something. But reviewing the Commonwealth's brief and their response to the argument, their argument is that we can infer from probable cause alone that a cell phone will have evidence and can be searched.
Right, and now that argument, the case that said you can't do that came out after this, correct? After that motion?
Well, I think the case that I cited where it specifically said it's not enough to say it may contain evidence
Right.
came out after the decision.
So and that was White or Onks? I forget which case it was.
I thought it was Broom, but
Broom,
I
that's
could-
it.
yeah,
You're
I thought
right,
it
you're
was
right,
Broom.
it's Broom.
But I think the trend was clear. I don't think it was a surprise. I think the court's decisions in Morin, in Broom, and just this last Friday in Perry lead me to the point where what I'd like to say is I'd like to focus on what I think is the difficult issue before this court.
Well, let me just clarify. I mean, I know White and Broom and recently Perry and Dorelis, but they're just nexus cases. There's nothing magical. This is, if we search something, are we going to find evidence of a crime?
Yes.
That's always been the law, correct?
Exactly. Yeah, exactly. That's why I say, I kept wondering, have I missed something? But it's a good example, actually, for law students that what we're trained to do is spot an issue and then research it. And this warrant simply fails, and it fails from existing law, I think.
Oh, why don't you go into the details? So they've got all kinds of, one, we have a murder. 2, we have your client has all the jewelry from the murder. Had they already made the connection to the pawn shop as well, and that he had gone to the pawn shop on the 5th of July, and part of the affidavit suggests, look, you're going to be making phone calls to find out if a store is open on July 4th weekend. I mean, it's not like there's nothing in this affidavit.
Well,
right?
I'd like to advise the court that that's not in the affidavit. That's in the Commonwealth's brief, that we can infer that you'd be making phone calls. The affidavit,
What does the affidavit say about the pawn shops and the, I thought there's something in there. Maybe I'm misremembering.
no, there is. And it's because the affidavit was not sought for several months after the homicide, because the phone itself was seized pursuant to an initial search warrant for the defendant's premises. And the cell phone they were looking for was the victim's. It took them a while to realize that the cell phone which they'd seized in that search, which was supported by probable cause, was the defendant's. Then came the second warrant. And we haven't challenged that the second warrant established probable cause that the defendant had committed the murder. But it went from that, and a recitation of the pawn shops, to simply say, therefore, evidence may be on his phone, including evidence of co-conspirators, where there's no evidence even in the affidavit of that. I truly believe that the challenging question for this court is whether it should order a 4th trial for this defendant, or should order these.
But before we got a lot to get through before you
Yeah, you
go
got a
there,
long
we got
way to
a
go.
lot to get
That was
through.
my 3rd issue. I was hoping to get there soon.
Yeah,
But we're not done
you
with
got
the first
a whole
issue.
lot of evidence against
Before
the
we get
client
there.
before you get
Excellent.
there. Yeah.
Go ahead. Well, so I guess I'll start with this. Why is it that in this situation where jewelry is found in your client's apartment that belongs to the victim 1 floor below, why isn't it a nexus to say, well, he would have tried to pawn this jewelry and would want to know where the location was? Maybe there's something as it relates to GPS. And why isn't that a nexus? Is it simply because they never say that in the affidavit?
Yes. I mean, that's the direct answer to the question. That was my realization when I kept reading the affidavit, when are we getting to the, and here's the reason why there will be evidence on this phone. And it's only the last paragraph. And it's the conclusory language that, based on my experience, there may be evidence on this phone. It's just not in the affidavit.
It's
And
just
I'm
the
not saying it couldn't
ubiquitous
have been.
argument.
Perhaps they could have written an affidavit and made a better showing,
Okay.
but they didn't.
All right, your point is it's just the ubiquitous argument that Davis doesn't allow.
Yes.
So if you're right, would the Commonwealth have found Crespo without the search warrant? Because that goes to the whole issue of I know you're gonna get to drugs and propensity and all of that, but before you even get there, if you're right, and we're looking at what the exclusionary rule is going to do, does that impact Crespo at all?
I think the honest answer to your question is it's not clear from the record whether their source for locating Crespo was the information taken from a search of his phone or from information taken from administrative toll records. That's not clear to me from the record. So I don't know. I don't know. And Crespo is my second issue, and he's the second issue for a reason. I'll get to the third issue on whether a retrial should be ordered, but we have to first address the evidence in this case that was allowed to be introduced by the Commonwealth regarding drug use. I just want to note this. 5% of U.S. adults report that they've been addicted to opiates or prescription medication at some time. Self-reporting, 5%. That would mean several people in this room, presumably. Are we saying that as a class,
Yeah, but why don't we,
people with the drug...
let's stick to the case for a second. You've got, not only is your client, the diamond ring is under his pillow, right, as well. It's clear that the doors are locked. This is an inside job, right? Her front door is locked. The possibilities are really three people. Vea, the son of your client's girlfriend, and your client, right?
I disagree with that.
Go ahead. Well, so how are all her doors going to be locked? And someone's going to, go ahead.
You'll recall that there was evidence that keys were missing. So concluding that it had to be somebody from inside requires that you assume that the perpetrator, right, didn't come in voluntarily, that the door wasn't open when he came in. It's no question that it's locked when the perpetrator leaves.
Perpetrator comes in and leaves all the jewelry and everything that your client discovers the next day.
But it's a robbery, and he's got the proceeds from the robbery.
Well, he has some of the proceeds. He has 2 items out of many that were taken. There's no question about that.
Well, and he's gone to the pawn shop the day after the robbery.
That's correct.
And he's hidden his name at first until he has to give a real name.
That's correct.
So,
So that doesn't go to his motive, as you know. I get the nature of the objection and how much it could taint someone, but isn't motive always? Can't the Commonwealth prove the motive?
It absolutely goes to motive, and it shows a motive may be theft. What's being challenged is the argument that addicts are more likely to steal than other people. Where do we get the basis for that conclusion?
Hold on.
Although
let's
he's
go ahead.
an addict, he's addicted to heroin, which is a hard thing to be addicted to. I know it's an opiate, not an opioid, right? So we're not talking about, there's really no other way, and he's broke. He's also broke at that point.
I respectfully disagree that that's what the evidence shows.
I thought
He's
he-
a
I thought-
one-income
I thought he's
household.
about to be evicted for not paying $971, and he got that notice. Is that also the day of the murder, too? Or the day before the murder?
No, and that was a prior apartment. He and his partner left that prior apartment, okay? His partner worked full-time. So I just want the court to take a moment and think about what we are concluding. You know, I think it's 20% of people live in one-parent households. So he doesn't work. His wife has a full-time job. He's so desperate for money, for how much? $20 is what the evidence may suggest, that he commits this crime. I'm simply asking the court to take a closer look at this drug evidence than we have done in the past. It is the classic forbidden inference. Somebody who stole in the past may steal again. Well, that might be true, but we forbid that kind of evidence.
And we look at this under our balancing test, correct?
Yes? Well, any trial court is supposed to look on uncharged misconduct evidence. If it is otherwise relevant, there is supposed to be a final test. Does its probative value, does it outweigh the prejudicial impact?
And I should know this, forgive me, but there was no limited instruction, correct?
No. Despite the fact that it was one of the Commonwealth's arguments is you could give a limiting instruction, it wasn't given. But again,
Was one requested?
yes. It was certainly discussed in the context of the pretrial efforts to keep out this evidence. The defendant fought vigorously, counsel, to keep this evidence out.
What do you mean it was just, he specifically said, I want you to give a limiting instruction if you're going to admit it?
My memory of the evidence is the judge said, and the prosecutor said, we can deal with this by a limiting instruction. But then when it came time for the instructions, it wasn't given, and I don't believe the defense reminded the court that it had said it would do that.
Was there a request for a voir dire on this to the jury?
Of Mr. Crespo?
No, of the jury pool. Was there a request for a voir dire?
I don't know. I don't know the answer to that question. I don't.
So what about, what do you make of the first floor apartment tenant testifying to hearing the scream, the running, the bang, and then no one coming downstairs?
Well, I certainly understand that that is evidence that the jury could say, well, it must have been somebody upstairs. But no one came downstairs. That man then went out in the car and played Candy Crush for a while. He never called anybody. So I don't know how he says nobody ever came down the stairs. Nobody came down the stairs right away. That's certainly true. Maybe there was time spent looking through the apartment by the perpetrator to find things to steal. So I just think we read a lot into I heard nobody coming down the stairs.
So on your, I promise this is my last question before you get to the issue that you really want to get to. But on your substance use disorder propensity
Yes.
argument, this is not some general propensity argument that somebody who has an addiction to even heroin is more likely to steal. That's not the propensity argument that's being made here. I mean, obviously, underneath all this, there is a propensity inference at some point, but it's carrying a lighter load. This is saying that he has a motivation to feed a habit, and therefore, that's why the crime might have been committed. That's not general propensity about people with substance use disorder, because those generalities, as you point out, are dangerous and often wrong.
You know, your question illustrates the point that I wish to make. I think you've stated correctly how we have approached these cases. But I want to suggest to you that to say that somebody with an addiction has a propensity first to do what? It's actually to do more, to take more substances. That's the propensity. And it is illegal. Heroin is illegal. So it's uncharged misconduct evidence proving that because he did something improper in the past, he will do it again. And that's what the author of that article that I cited is pointing out, is we're not logically addressing this in our case law with respect to uncharged misconduct evidence. And again, I think it is highly questionable for us to continue to believe that somebody who needs $20 to get something they're addicted to is more likely to commit a crime, a robbery, a murder. I think that comes from tropes that just fall below what we can expect for reliable evidence. And it certainly, its probative value is far outweighed by the prejudicial value. And
I think the point Justice Lowy made is that it has to be particularized, not general, as to someone who has a substance use disorder, correct?
Yes, and I think I do cite a case where the proximity of the drug-seeking behavior is just closely related, within moments, I think, or an hour or something. And in this case, I want to urge the court, when we talk about
Although
Ali
it's a little
Crespo,
hard to do this. I mean, he's certainly willing to receive stolen property, right?
yes,
So, so he wants the money enough that he's going to steal property or receive stolen property, right? So it's not like this is some kind of, person we can't judge motive at all about. I mean, I'm confused by what you're saying here. This is not we're looking at someone with a drug problem and whether they've committed a crime in general. It's a very specific crime in a very specific place, and we're trying to figure out the reasons for it.
that's true. But the issue in this case was the perpetrator of the homicide.
Right.
And there is a disconnect between somebody who is trying to get money and somebody who commits a heinous crime.
But, well, you know what the DA is going to say? The DA is going to say the specificity here is they go straight from the pawn shop to the drug use.
Well,
It's
that
the
comes...
specificity.
That comes only if you accept Ali Crespo's testimony. And I have produced it in its entirety in the transcript, in your appendix, because there is no connection in evidence as to when that happens. The Commonwealth certainly believed it. They certainly wanted it to get into evidence, but it didn't come in. That's why when I write in my brief, Ali Crespo's testimony is unmoored in time. It's simply, we were in drug rehab together. We used heroin together.
This is an important point as it relates to the probative value, undue prejudice, and as to the whole argument you're making. You're saying that, because the judge isn't dealing with credibility here, so you're saying that on this record, what their suggestion that they go from the pawn shop to taking drugs, that's not true in this record.
That's exactly what I'm saying.
That he's actively seeking drugs
Yes.
is your point,
That is my point.
or the absence of that evidence.
And you won't find it in Ali Crespo's testimony. You'll find the Commonwealth hoping to get it, and I certainly understand why, but you won't find it. It didn't come into evidence.
You've got that issue you want to get to.
I do, but in my view, it is important that the court will have to address this drug use issue I'm talking about, because of course, my argument is that he should not be subjected to a fourth trial. And I think I've offered the court plenty of ways to get there. I recognize that the double jeopardy argument is the least likely route for the court to take, but I want to address what I think is the likely route, and that is following your decisions that are mentioned in Kerouac, the Funches and the Silva decision, that says when we, as a reviewing court, can look at the evidence offered by the Commonwealth without what should not have been admitted, and we determined that had the correct rulings been made, there would have been insufficient evidence, and therefore double jeopardy requires that we dismiss this indictment. That's the most direct route. And I certainly have acknowledged that the court has also said in Bacigalupo, we don't do that.
So it's really skipping a point where usually that happens in front of, there's a motion that's brought. If you lose, you go up in the single justice and we review it. So you want us to skip that remand possibility and just decide that issue?
Well, this was the discussion that my client had several years ago. We probably could have been successful in a motion for new trial at the trial court, and he would have had a fourth trial.
Can you tell me what, if any, difference there was in the evidence in the different trials?
The only difference which I've been able to determine is that in the third trial, the Commonwealth chose not to play the videotape of the defendant's interview with the police, where he is saying, I found these items in a trash bag outside the house. That's the only difference which I can tell in the evidence.
Can you go back to what you just said about the motion for new trial, that you decided not to win that?
Yeah. Well, not to win it, not to file it in the, well,
Right.
we're required to file it in this court, as you know. But and ordinarily they're remanded. We ask that that not be done, that it be consolidated, because there is such a strong case that his double jeopardy rights have been violated. We wanted to have it heard at one time.
But
In either way, it's the sufficiency of
Yes.
an affidavit. So you're not going to get anything by a motion hearing.
No, I think we would have then had to file here to have the double jeopardy issue reviewed. It just made sense to put them together. again, hoping I had spotted the issue right. I believe I have. And I think, as I said, for me, this is the challenging part is there enough left over, if the defendant is correct about the impact of the phone evidence and the impact of the improperly admitted drug evidence, is there enough left over to warrant conviction? There's no question it's suspicious. And I guess that gives me a chance to end by doing something. Most of my career was as a prosecutor, so I never got the chance to read this. But I'll leave you with this. This is what John Adams said before this court in his closing argument in the Boston Massacre case. He first said something we're all familiar with. We are to look upon it as more beneficial that many guilty persons should escape unpunished than one innocent person should suffer. But he added a note of explanation. The reason is because it's of more importance to our community that innocence should be protected than it is that guilt should be punished. I recognize the suspicion that the facts pose on the defendant, but in this case, after 3 attempts, the Commonwealth has not produced sufficient evidence to satisfy the standard of proof beyond a reasonable doubt.
Thank you,
Thank
Mr. Votero. Attorney Doherty?
Good morning. It's Andrew Doherty for the Commonwealth. And may it please the court, I'm asking that the court affirm the defendant's conviction for the murder of 88-year-old Hilda DiVincenzo. I will start with the cell phone search warrant. And the last trial in this case took place prior to Onyx White that handicapped the probable cause analysis for a search warrant by saying you can't rely on the ubiquity of cell phones to do that. That case is not issued by the...
What difference does that make?
Well, there is some, I think there's some reliance on the idea that this defendant, when looking to dispose of the property that he had stolen during the murder, had used his cell phone to...
No, but as far as the legal standing goes, what difference does that make?
Because the question when the search warrant hasn't been filed, and that's the error that's being claimed, is whether a motion to suppress would have been successful.
That's the issue we had in Commonwealth versus Moran, and we found that it was improper. It should have been filed.
That it should have been filed.
Right.
Right, but here...
Because it's purely a nexus issue, which should have been spotted.
Right, and I think with Onyx White, where the court invents a new way to consider the special nature of cell phones, that no one prior to the issuance of Onyx White would have considered that argument.
I don't know if I agree with inventing, because every time we say you get to search something for something, right? You get to search the house to see if there's drugs there. We require the government to say why there are drugs there. So now we have a cell phone, and we say in White, other than it just being a cell phone, tell us why there's evidence of a crime in this cell phone.
I'm not sure that's all that Onyx White said, because Onyx White agreed that cell phones were ubiquitous and that everybody uses them, and then said that's not something that a detective can rely on.
Well, my memory of Onyx White was that it was a joint crime, right? And then the detective said, well, I know that when a bunch of people get together, there's going to be evidence. And we said, well, just because everybody has a cell phone doesn't mean there's going to be incriminating calls in the cell phone, right?
I disagree. I think it was a bit more revolutionary than that.
It's retroactive. I mean, it's a common law decision. It's not prospective. It's whether we were too inventive or not is besides the point. It's the law we apply, because it's not. It's as a common law ruling, it's retroactive, right?
To some extent, but if a motion to suppress would have been allowed by relying on a case that hadn't on a newly invented law, in order for the motion to be
A newly invented statute, yes, but this is not. This is a common law decision, and this is a first-degree murder case, right? So I'm not sure how that helps, right? Because we skipped the first step.
So,
right.
well, the first step is would a motion to suppress would have been allowed? And if the denial of that motion, or sorry, the allowance of that motion to suppress was relying on the use of the.
That's for ineffective assistance, right? We look at it in a first-degree murder under 33E as well, correct?
You do.
So if
And-
evidence wouldn't have been admissible today, is it really fair to say that, good enough 5 years ago?
I mean, in some respect, and I don't want to spend too much time on this because.
Well, maybe we do.
Well, but what I say, we may be putting, this may be a case where you put the cart before the horse, and you look at whether there would have been
Let's get to brass tacks, though. I'm looking at paragraph 4 on your record appendix of page 45. That seems to me to be the key paragraph as to whether or not there was probable cause. Is that true?
I'm looking at paragraph 4.
The phone may reveal Melendez's location before, during, and after the murder. It may reveal planning correspondence between Melendez and accomplices. May also show who he contacted after the murder.
Right.
That's the long and short of it, right?
It is, and first, I mean, Dorlaw says you can't use the word may, you have to use the word
Right, but
must.
look at Perry that just came out. The difference between search warrant 1 and search warrant 2.
Right.
Search warrant 1 is this general language, and search warrant 2 was specific.
So here, you also look to the nature and type of crime for which there's probable cause established in the affidavit. And here, where the evidence established, one, the probable cause of the defendant murdered Hilda DiVincenzo. Number 2, that he stole, in the course of that murder, numerous items from her, including multiple pieces of jewelry, strong boxes, et cetera. And number 3, that by January 9th, he had pawned one piece. That
That
was
would have been
certainly-
great if that was in the warrant.
That was in the warrant.
No, that it also said, and by the way, we know that he's going to use a cell phone to contact pawn dealerships.
Right, but I think you're allowed to look at reasonable inferences that are born from the facts that are made in the statement, and it's not fatal to a search warrant application that the officer doesn't bring up what is common sense. Post Onyx White, there would have been more information that was added, but we didn't have the benefit in 2013 of any of the guidance from these cases. But that would have been, especially given that he had his.
You're basically arguing for a good faith exception.
Yes, to the extent that I would also argue that it is unnecessary in this case, where you look, like in Cowan, where you look to the nature and types of the crime and the overall circumstances that are established to show that, yes, a person in 2013 would have used a cell phone over a holiday weekend to.
Yeah. Can you tell me how paragraph 4 and this request to search the cell phone for so many items? I mean, it wasn't just, I want to look at I mean, they wanted to look at a lot of things. How is it different from a general search?
So first, I would say the 2 key components are the communication and the location information. Those were what was, and you can summarize most of the stuff that they're looking for based on communications, who he's speaking to and how he is speaking to this person. Photographs, I think this court has found photographs can be used as parts of the communication.
But he also, they wanted, if you look at paragraph 6, they wanted his stored electronic mail, text message, video messages, address book, GPS information, contact lists, personal calendar, to-do list, history of calls sent, received, and missed, and any fruits of instrumentalities. So it just seems like that's just like, let me just look through your phone.
And again, this warrant was issued prior to Dorlass. It talks about the more particularity being necessary in order to do that.
This wasn't a new concept.
I think it was in 2013, right? It was prior to cases like Dorlass and Broom that talk about more particularity being necessary. But what happens, the secondary question is, if this was a general search warrant, what does one do but exclude those things for which there wasn't probable cause and instead focus on the things for which there was, right? And so we still would have communications. we would still have location information. I would argue you still have search warrants, and those were the, web searches, and those were all the kinds of things
How
that.
you get the GPS data, because we distinguish, this this meets the GPS standard, but I'm not sure you get the other things. But it doesn't matter here. I hate to ask,
Well-
because, I mean, there's so much other evidence. What do you get from the phone that you don't have elsewhere?
Agreed, and I make that point, and that's why I really do think it's okay here to put the cart before the horse and talk about whether there was a substantial likelihood of justice.
Justice.
The other, right. Sorry.
We hope there's a substantial.
Right.
But, you know, one last thing, because I'm confused, as have been my colleagues here about, well, what was the law then? Because, and you mentioned it again with the ubiquitous and the particularity issues, and you keep on going back to what the law was at the time the motion to suppress would have been filed. But prong one is not measurably below reasonable lawyer. And prong two is substantial likelihood of miscarriage of justice of the entire record at the time we're reviewing it. So I'm having a hard time, as my colleagues have had, of understanding why you want us back in, when was this, 2013?
2013 was when the warrant issued.
Why-
2016, after Dorlass and Broom, prior to Onyx White.
Okay, so why is it that's where we want to do our analysis? When we're in a first-degree murder, so prong one's different, and prong two's different, and we're applying substantial likelihood now. And so I'm having the same problem on what doctrine we're applying.
I referenced a case in my brief that I believe was a first-degree murder, where I mentioned it's the precedent at the time of the trial that dictates. And it was a recent case. I believe it was your decision, Justice Kafka. And if I'm misquoting it, I sincerely apologize. But I understood it to mean.
Which case are you referring to?
This was Commonwealth v. Lewis, where a determination of trial counsel was not ineffective in moving to suppress pretrial identification or excluded at trial was tied to precedent existing at the time of trial, where the question was, I believe, would a warrant to suppress, a motion to suppress, would have been successful at the time of the
I guess
trial?
the issue is, though, we have the 33E overlay.
You do.
So, I mean, that gets you Safarian, but we go beyond Safarian.
Sure, and if that is the case, then the question then becomes, is there a substantial likelihood of a miscarriage of justice, and did this influence the jury? I would point the court to its decision in Morin, when it talks about how central the text messages that shouldn't have been a part of the trial record were to the Commonwealth's case. This is not that case. In fact,
So what's derivative of the cell phone?
you have cumulative evidence of the defendant's heroin addiction, which was established through Ollie Crespo's testimony, as well as the calls that were made shown in the toll records to the rehab centers shortly after the murder and a couple days after
Get to
that.
Crespo without the phone? Crespo's one of the contacts in the phone. Do you get to him without the phone?
Well, we have his call records, and we pursue to a separate process, and we have the fact that it is Ollie Crespo, based off of other process, which it looks like it was another administrative subpoena for subscriber records associated with that phone number. So that would have been found without, and there were no text messages or anything to Ollie Crespo.
You have Crespo speaking to him within the relevant time frame.
Right, they spoke on.
Under subscriber information.
Right, we see him talking, a phone call on July 5th. And that, coupled with the calls to the various rehab clinics, shows that he was struggling with heroin at the time. And I don't want to understate how compelling the other circumstantial evidence here was. The opportunity perhaps was the strongest, and motive was much more secondary to the strength of a circumstantial case where there are three people in a locked building, one of whom hears the murder, and the other is the victim.
I'm sorry, I can't resist saying this, though. This really strong circumstantial case is a mistrial twice, a Tui Rodriguez charge in the third case, and days of deliberation after the Tui Rodriguez charge.
Sure, and I'll say this, it's hard enough to convince 12 people about a direct evidence case. It is harder to prove beyond reasonable doubt to 12 people, not just what the facts are, but what inferences can be drawn from those facts.
Does that reasonable point help you or hurt you?
I think it helps us. This was an entirely circumstantial case, and it's going to be a challenge for any jury to do that, and I wouldn't read too much into the fact that there was 2 hung juries prior.
But we're doing an analysis of what the prejudice was.
I'm sorry, I missed that part.
We're analyzing whether it's substantial likelihood or prejudice. We're analyzing how important this evidence was.
Sure, and I guess if the question is evidence that was derived from the cell phone or evidence that was...
Well, you're making the point that this is a very strong case anyway, putting aside the cell issue so that it should be affirmed anyway, even if it was error not to file the motion or even if there wasn't probable cause for the cell phone. And I'm just making the point that when you say how hard the case would be to prove, I'm asking you if that helps you or hurts you.
I would say the strength of the Commonwealth's case and the strength of the circumstantial evidence remains unaffected by what came in through the cell phone, which was all about opportunity, right? Nothing on the cell phone speaks to the defendant's opportunity to do this. Nothing about the defendant's heroin usage speaks to the defendant's opportunity to do this. And the
Going
strength...
back, I'm sorry.
Thank you.
I'm just still stuck on this general warrant issue. And if they had done their search warrant, and instead of saying we want to search the phone, we said we want to search the defendant's apartment, we want to look at all his mail, we want to look at his calendar, we want to check all the to-do lists, whatever's hanging on the fridge that I have to do. And all of those, we would just like to look through his mail and his personal effects to see what we can find.
Well,
Why wouldn't that would be wrong, right?
I think if instead they said, we want to look for his communications, that would be correct, right? And
Stored electronic mail, that's communication?
That's communication.
So if I want to look through all his mail at home, any personal mail that came in, that'd be okay too?
I think if they had looked at things that were outside the realm of what probable cause is established, you would exclude those portions of those things. And if the remedy isn't to exclude everything, but rather to look and determine what was obtained as the result of a general warrant and what wasn't. And here, there's communications, those come in, location comes in, efforts to sell or dispose of this property, all of that speaks to the communications that were obtained, really everything but the web searches. And even then, it would be reasonable to conclude that somebody would Google pawn shops that are open on 4th of July weekend in order to sell these things.
Okay.
I'm not sure if that fully answers the question, but I'm not sure. I raised my policy arguments with respect to the question whether the court can dismiss these in the interest of justice when there's been 2 hung juries.
Do you want to talk about the prior bad acts, though, and the issue of the propensity?
Sure. So the evidence of the defendant's heroin usage was timely. We showed that the evidence showed that he was calling pawn shops an hour or so after the murder had occurred, and that he was looking to sell these goods. Ollie Crespo testifies that he went to one pawn shop with this person in the entirety of the time knowing him. It was on Route 16, either in Everett and Revere. That's where the pawn shop was located. And that they went back to the house and did heroin. So the question of whether, well, first of all, it is strong motive evidence that somebody who is addicted to a substance has a greater motivation to do things or that there was a driving force for why he was doing this. It's the difference between not having food, I think, and starving, right? And so that's the essence of addiction and addictive substances, is that it creates a need that isn't otherwise there. It doesn't speak to his propensity to murder or his propensity to steal. And in fact, that was discussed at length during jury voir dire. There were 2 questions posed to every juror by the judge with respect to any biases or prejudices that would come or conclusions that would be drawn by the fact that there may be evidence of heroin use. But also, defense counsel during individual voir dire asked nearly every juror the same series of questions, really testing whether they would find propensity evidence in somebody's heroin usage. So,
What's your view of the record? Because the appellant's view of the record is different. The motive, like many other prior bad acts for non-propensity purposes, has a narrow propensity inside of it. And one of the things here that seems important is that they went from the pawn shop to getting the drugs to using them from Crespo's testimony. But the defendant's position is the record doesn't bear that out.
so I will concede that Ali Crespo's testimony is confusing at times, but it does support, and you'll see him conceding and agreeing and saying, probably we did this, maybe we did that. I wasn't there the whole time, but yeah, we went back to my house, and we did drugs. And and it was after the defendant drove me to the store to do that. So it is not, certainly not the strongest evidence that he was, but it was reasonable certainly for the Commonwealth to offer it as evidence. The fact that it didn't come in as well as we would have liked is really secondary. There was certainly no accusation that it was going to be any worse than that.
Can I ask one factual question? The pawn shop, is that dependent on the phone, or did they have the pawn shop information separately from the phone?
Sure, they had it separate. It was, they had been sort of canvassing every place that could have sold these devices, and
Okay.
were lucky enough to find
I gotcha.
that store.
Okay.
Any further questions? I'll rest on my brief. Thank you.